So, what is mediation? Well, mediation is a process by which a neutral third party, me, facilitates communication negotiations between parties to a dispute with the ultimate goal of the parties themselves voluntarily reaching a mutually acceptable resolution of their dispute. Now, mediation has four basic characteristics. First, it's voluntary. That means if you don't want to settle, you do not have to settle. You can get up and leave anytime you want. Second is self-determination. That means that if you do reach a settlement, the terms of that settlement come from you all. They don't come from me. I don't impose terms on parties. Third is neutrality. Now that does refer to me. That means I have no bias for or against either party, nor do I have a bias for or against any particular resolution of your dispute. In addition, I like to confirm that I have no conflict of interest. That is, I have no personal, business, or financial relationship with any of you all. I also like to confirm that's true with regard to my old law firm. Its name was Dowlonis. And my wife's current law firm. Its name is Davis Wright Tremaine. The fourth characteristic of mediation is confidentiality. That essentially means that all communication in mediation, written or verbal, is confidential and will not be disclosed to the court, judge, or jury. Now, because confidentiality is a legal concept, that means there are exceptions to the general rule. And among these exceptions, I may be required to disclose to the appropriate legal authorities any communication in mediation that relates to elder abuse, child abuse, spousal abuse, any threats of physical injury or bodily harm, or any intention to commit a felony or other crime. Now, what are our relative roles in mediation? Well, my role as the mediator is actually pretty straightforward. I'm here to help you in your negotiations and your discussions. I'm here to assist you and go over the facts, see what facts, if any, are in dispute, help you identify all the key issues, help you get all those issues out on the table, thoroughly discuss them, and then at some point help you generate and evaluate possible options, proposals, offers, counter-offers for resolving your dispute. In addition, at times I may engage in what is called reality testing. That's just a fancy way of saying that every once in a while I may ask some pointed, tough questions about the feasibility of certain positions you may be wanting to take or proposals you may be wanting to make. Now, besides understanding what I do as a mediator, it's also important for you to understand what I don't do. What I don't do is I don't decide anything. I don't decide what's fair, unfair, true or false, legal or illegal. I also do not provide legal advice, nor do I act as an advocate for either party. Now, what about your roles in mediation? Well, in general, I have found that you may significantly increase the likelihood of settling your dispute in mediation if you adopt two attitudes. The first attitude, and it's not going to be easy, but the first attitude is if you could adopt a certain flexibility in your position and openness in your mind. Now I understand. That's very hard to do. You're in the midst of a contentious legal dispute. I think it's to your advantage to at least make the effort. The second attitude is if you could every once in a while try to step into the shoes of the other party and view the dispute from the other party's point of view. Now, that doesn't mean agreeing with the other party's point of view, but it does mean trying to understand the other party's point of view. I believe if you adopt these two attitudes of understanding and flexibility of position and openness of mind, that you may significantly increase the likelihood of settling your dispute in mediation. Now let's turn to our second main point, which is the agreement to participate remotely in the meeting.